Good afternoon and welcome to IDA Ireland and CFO India exclusive live webinar. This webinar is designed for entrepreneurs, CEOs, CFOs, CMOs, CISOs, business development and strategy teams, R&D and legal teams, consultants and advisors, and is being presented in two parts. There will be two presentations. One presentation will be by two leading European intellectual property experts, Declan Lavelle and Senior Associate William Fry Tax Group, and Brian McElligott, who's Senior Associate William Fry Technology and Data Protection Group. The second presentation will be by Tanaz Bohariwala, Director for IDA Ireland in India. Now, just to introduce our speakers today. First, I would introduce Tanaz. Tanaz, as I said, is Director for IDA Ireland in India and has worked with IDA for over 7 years. Along with the team, Tanaz helps Indian companies set up in Ireland and leverage their Irish presence to trade across Europe. Previously, Tanaz worked for the British High Commission in India, helping British companies do business in India and Indian companies set up in the UK. Over a 25 years career, Tanaz has engaged with MNCs, conglomerates, large corporates, SMEs, and startups alike, helping them in their plans for European growth. This has helped to develop in-depth experience in aligning company needs to business opportunities in the European market. Some companies Tanaz has recently assisted expand their footprint within Europe include SCL, NIIT, Tech Mahindra, Biotech, Chartered accountant. Declan spent a number of years at a Big Four accountancy and tax firm before joining William Fry in January 2015. Declan specializes in international tax matters and regularly advises companies on all tax aspects of establishment in Ireland, focusing on structuring intellectual property through Ireland. He has experience advising clients on a wide range of cross-border transactions, including corporate reorganization, mergers and acquisitions, inversions, financing structures, real estate transactions, transfer pricing, and other related domestic and international tax issues. Brian holds a BA Mod in Theoretical Physics from TCD. Brian specializes in the strategic protection and development of intellectual property, including the context of international IP structuring and commercialization projects. His extensive experience covers outsourcing, commercialization of IP, SP7 projects, and anti-counterfeiting. He is also a registered Irish and community trademark and design agent. He has experience in advising clients on negotiating high-value contracts and large-scale projects, including outsourcing and system supply, as well as general commercial activities such as procurement of IT systems, software licensing, application development, systems integration, support services, export control, and cloud computing services. He also has experience with advising on consumer law, consumer marketing, competition, and data protection, including the GDPR. Now, you must be wondering why Ireland? Ireland has been an attractive jurisdiction for setting up entities for holding intellectual property-linked sources of income to maximize the after-tax profit arising therefrom. Advantage Ireland as a smart, efficient economy for holding of IP-based rights has been brought about due to a combination of both its domestic legal framework, providing sufficient legal protection for IP rights, and its overall administration. Now, I request Tanaz to take us through the key points of why one should be looking at Ireland. Tanaz, over to you.
Thank you very much. Hello, everybody. It is IDA Team India's pleasure to host yet another webinar as we aim to address queries our client base and contacts have about Ireland and about doing business in Ireland for Europe. This time, we bring you this webinar that is aimed at helping understand why Ireland is a popular EU hub for IP development and exploitation. I thank Brian and Declan from William Fry for agreeing to do this and join us today. Ireland as a jurisdiction offers tax efficiencies and the system is robust, transparent, as well as OECD and BEPS compliant. Without taking too much time, I will quickly share a snapshot on Ireland with you, as I'm conscious we also have people joining us today who may not be familiar with Ireland. Ireland is home to 4.7 million people and is a committed member of the EU. In fact, Ireland is the fastest growing economy in the Eurozone today. There's free movement of people, goods, and services within EU member states, and post-Brexit, Ireland will be the only English-speaking part of the EU. This, coupled with the fact that we follow the common law system in Ireland, makes it an even more attractive country now for most companies that wish to operate in the EU. IDEA has assisted over 1,400 multinational companies to set up and operate from Ireland. This includes the top 10 global ICT and pharma companies, the top 20 global financial companies, 14 of the top 15 global medical technology companies, and many other companies across the value chain of all sizes in the above sectors, as well as in niche subsectors like robotics, cybersecurity, data analytics, smart materials, automation, and augmented reality, amongst others. Ireland also boasts a rich pool of local Irish companies as well. Companies like Microsoft, Google, Facebook, Intel, IBM, GSK, Pfizer, J&J, Apple have all made Ireland home, as have a number of Indian companies. Here's a snapshot of some companies that IDEA Team India have assisted with. All these are in Ireland, as besides the tax system, the cluster of companies we boast of, and the fact that we're part of the EU, we also have a young, highly skilled and productive workforce. Besides, there is low bureaucracy in Ireland, and it is easy for businesses to focus on and do their business. Ireland consistently ranks high in various surveys and reports on ease of doing business, on ease of setting up and paying taxes, on the availability of skilled manpower, amongst other factors. This year, the World Bank ranked us number 1 in the EU for ease of starting a business, and for the last 3 successive years, we've been ranked in the top 5 by Forbes as the best country in the world for doing business in. I promised to be brief, and here was a quick snapshot on Ireland for businesses. Happy to address any questions later anyone may have on Ireland and on doing business or setting up in Ireland. To quickly summarize who we are, IDEA is the Irish government's FDI agency. We work with companies to understand what their European expansion plans are, and we jointly explore whether Ireland could form a part of their plans, whether they could set up in Ireland and service European companies from Ireland. We help by providing market and competitive information. We make relevant introductions within the ecosystem, and we provide government support, which includes financial assistance. Again, happy to discuss this later on a one-on-one in the near future. My contact details are given here. And with this, I hand over to the William Fry team to take this forward. Thank you.
Thank you, Tanaz. We will now move on to the next part of the webinar. Declan and Brian will tell us in this part how companies can successfully leverage the Irish jurisdiction for setting up entities for holding intellectual property-linked sources of income to maximize the after-tax profit arising therefrom. Over to you, Declan.
Thank you, Sangeeta, and thank you, Tanaz, for that introduction. Thank you, everybody, for joining us, and good afternoon. We appreciate this is a busy time of year for you all, with the year-end coming up for many companies. I'm going to discuss some of the tax benefits, first of all, that Tanaz has touched upon, and give you a brief overview of what Ireland offers in terms of tax benefits. In the first instance, what Ireland is very well known for, and what's been core to our FDI policy over the number of years, which we work close with the IDA on, is our 12.5% tax rate, which is a very beneficial and low tax rate. There's a commitment to the 12.5% tax rate across all major political parties in Ireland, and it applies to the majority of income that arises to most companies in Ireland. We do have two other tax rates: the 25% tax rate, which accrues on rental and interest income. We also have a 33% capital gains tax rate, which applies on disposal of capital assets. In terms of extracting cash and cash repatriation, Ireland has generous offerings in terms of withholding tax exemptions for interest, royalties and dividends, which makes it a very attractive location to be your EU hub or a global hub across the world and allow you to repatriate cash back out of Ireland in a tax efficient manner. In addition, we have a generous holding company regime. We provide for a full exemption from CGT on disposal of certain shareholdings which are deemed to be trading companies. We also have a credit-based system for receipt of dividends, which basically provides for a 0% effective tax rate. We have an extensive treaty network of almost 72 treaties. We have no PIN cap or no CFC rules in Ireland currently. And underpinning our entire tax policy is our attractive tax IP offerings. This includes the tax depreciation on IP, which I'll discuss in further detail. We have a generous R&D tax credit regime. We have a recently introduced knowledge development box, which provides for a 6.25% tax rate on qualifying profits. And in addition, there's a stamp duty exemption on sale or transfer of IP, which is relevant if you're looking to move your IP onshore into Ireland. So moving on just to a select summary and comparison with selected jurisdictions. You can see we have a generous regime in comparison to other popular holding jurisdictions such as Netherlands and Singapore. And our understanding is the USA is also a popular destination for Indian companies. Clearly the USA are going through a series of tax reforms and we're still waiting to see what comes out of that. But in terms of preferential regime, Ireland stacks up very, very kindly compared to other jurisdictions in terms of where you might look at hosting your IP from. In terms of a brief overview, the 12.5% tax rate is very important to Ireland. There is substance required. It's based around jobs, it's based around people. The government doesn't like letterbox type of entities whereby there is no people on the ground or no employees. There's a strong commitment to 12.5% tax rate across all parties, and there's a strong commitment to it, and that provides certainty to taxpayers that rate will not change, and the rate has remained unchanged since it was introduced in 2003. As discussed, there's a broad exemption for withholding taxes from dividends, royalties, interest. In terms of IP planning, and I'll touch on this later on, there's been a significant uptake among multinationals of the tax depreciation IP, which came about through onshoring structures in light of the global focus on IP structuring, and in particular structures such as the double Dutch sandwich or the double Irish, among other types of IP planning structures. So people have moved away from that and have been looking to onshore IP onto more BEPS-friendly and OECD-compliant structures such as Ireland. So we've seen a lot of people take that up, and I'll discuss that in more detail in the next couple of slides. We've also seen a large uptake in relation to our generous R&D tax credit regime, which provides for a 25% tax credit in addition to the 12.5% standard deduction that companies get for their R&D tax expenditure. As discussed previously, well, there's a KDB regime, knowledge development box. This was designed with BEPS in mind, and it was the first OECD-compliant IP box, and it follows the modified Nexus approach as outlined in the BEPS project. In terms of transfer pricing, in general, we follow the OECD rules, but it only applies to transactions that are taxable at 12.5% tax rate, and that's because we have the two different rates of 12.5% and 25%. So the reason it only applies to 12.5% rate is if we had transfer pricing across the board, it could lead to tax inefficiencies for Irish companies if they were to have to transfer price between various non-trading transactions. There's currently a consultation process underway in Ireland to examine our approach to transfer pricing. That's on the back of a coffee report and a few different recommendations that have been made across the board by people such as ourselves and the Big Four and everything else in terms of how we can improve and modernise our transfer pricing legislation. As Shanaz mentioned, we've been fully supportive of the BEPS project, and where necessary we will amend our legislation in line with the recommendations of BEPS, and as mentioned there's a process underway to look at and enhance our transfer pricing regime. So moving on to our tax depreciation regime, as discussed, is a very popular benefit that people have availed of, multinationals in particular, over the last number of years, particularly with the closure of popular IP tax planning structures such as the double Irish, the double Dutch. People have, we have seen a strong move for people to onshore into more BEPS-friendly jurisdictions such as Ireland and move their IP onshore. So effectively this allows for tax depreciation. It can be over the life of the accounting life of the asset in the accounts, or for longer life assets, it can be 15 years. The company needs to be a trading company, so again, that goes back to substance in Ireland's requirement to have employees on the ground and not be just a pure holding company for IP. It needs to have people that are actually managing that IP and people on the ground. So essentially, there's an 80% annual cap for any interest and tax depreciation incurred on the asset. And this operates by basically leaving 20% of IP income left within the charged tax. And essentially, a 2.5% cash tax rate is achievable through the IP tax depreciation regime. So obviously a very generous, effective tax rate that people can achieve on that. There's no clawback of the allowances if the IP is held for at least 5 years. So, ultimately, if you were to go and sell that asset down the line, there wouldn't be any clawback of this relief that's available. And also in terms of interaction with the R&D credit, if there's R&D activities also going on, there is the possibility to reduce your effective tax rate even further. Moving on to R&D tax credits. So as I mentioned, there's a €25 tax credit in Ireland available. This is in addition to the 12.5% deduction that's for ordinary trading expenses. So this provides for a 37.5% overall benefit in terms of your R&D spend, which obviously is a very generous relief also. One of the key attractions of this is that there are cash refunds available. So for companies that are in, for example, a startup position or are heavily investing in R&D activities, they may be loss-making in the early years, and obviously if you're loss-making, you will not be in a tax-paying position. How this works is that the cash refunds can actually be repaid over a period of 3 years. So even though you're not generating a tax liability, this does allow for 25% rebate of your qualifying spend, and therefore it can be a very generous incentive for companies who are looking for funding and for ways to fund their continuing and ongoing R&D activities. There is also an outsourcing potential, so there is room and scope to outsource some of your R&D activities to universities and other specialists in Ireland. And we have a very strong R&D and university network in terms of IP and innovation, and there's certain hubs in different universities that specifically look at this area and look to support companies in this area to enhance the R&D offerings of each company. Just looking at a quick example. I'm sure Shanaz can discuss this in more detail, but if you set up in Ireland in certain locations, the IDA may be in a position to provide you with a grant, in addition to obtaining certain benefits in relation to your R&D as well. So if we take an example that you've got 1 million of R&D spent in Ireland, let's say you get an IDA grant of 120,000, you can also get a corporation tax deduction of 12.5% of your 1 million, but also you could also get an additional tax credit or benefit of 220,000 in terms of the R&D tax credit, be it by way of a tax credit or by way of a refundable tax rebate. So in terms of a 1 million spend, the actual total cost to the company could be as little as 535,000 in that situation. And it's just a quick calculation on the right-hand side of that screen to show how you would calculate the R&D tax credit. So again, there are many ways in which you can maximise the benefits that are available in Ireland in terms of your R&D, and it's something that the government heavily focuses on in terms of bringing in innovative and good jobs into Ireland in this space. So again, as I discussed, in terms of the refund, you can see over 3 years, depending on each year, you can get a refund. It's spread over 3 years. You don't get the full amount back in year one. But let's say in year one you spend 220,000. That's spread over 3 years. So you can see the cumulative effect at the bottom line based on your ongoing spend on a yearly basis, that it does allow for generous refunds of tax credits and rebates where available. So in order to be R&D, the work must be basic, applied or experimental research. It must be deemed to be systematic, investigative or experimental activities. It must be within a revenue-approved field of science and technology, which is quite broad. I mean, it would include many types of software development, pharma products, engineering. So it's a very broad definition in terms of what the approved field is, and there's numerous types of activities that fall within that. It must involve the resolution of scientific or technological uncertainty, and again, that would follow the best practice and OECD guidance in terms of R&D, incentives and credits that are available across the world. And it must seek to achieve scientific or technological advancement also. That's the kind of key fundamentals in order to determine what an R&D activity is and whether it falls within the ambit of the R&D tax credit regime. As I discussed, there is scope to outsource to certain universities or certain subcontractors. There are limits on how much you can, but again, there is generous amounts available. It's greater of 15% or 100k to subcontractors, or the greater of 5% or 100k for universities. So again, it does allow companies to, I suppose, leverage the knowledge and the expertise of certain PhD activities or certain master's students in UCD that can help out in certain areas of their expertise. So again, as I discussed, we have a knowledge development box in Ireland. This provides for an effective 6.25% tax rate on certain profits. So the KDB applies only to a specified trade. So a specified trade consists of one or more of managing, developing, exploiting IP, researching, planning, developing, leading to the creation of IP, and the sale or goods supply which derive part of their values from the above activities. So the type of IP that qualifies in this regard is inventions that are protected by patents. In addition, there's copyrighted software that can apply. As I discussed, the first OECD compliant IP box. So it follows the modified nexus approach and is it meets the latest OECD standards in terms of IP boxes and similar regimes. So I have a worked example here. I'll just give an idea of how the modified nexus approach works. But effectively, it takes the qualifying expenditure on the qualifying assets. There's also an uplift expenditure available, which is the UE, and that's the lower of the 30% of the qualifying expenditure or 30% of the aggregate of, for example, acquisition costs or group outsourcing costs. So there's generous kind of benefit available for costs which aren't directly attributable to the qualifying expenditure, but it does allow for a certain uplift in the total qualifying profits. OE is the overall expenditure on the qualifying asset, so it's basically just looking to apportion your qualifying expenditure versus your total expenditure. And obviously QA then is the actual profit of the specified trade, which is the profit from the qualifying asset. So basically taking a simplified example, just if we ignore the uplift expenditure for a moment, if we work out the various qualifying expenditure, the overall expenditure, and also the qualifying profits, basically how it works. So in that example, if we're left with 2 million of profits for KDB purposes, in terms of computing your corporation tax on that, an allowance of 50% of the qualifying profits is available to be deducted against the profits. So essentially 1 million is allowed to be taken off your profits, which leads to a 6.25% tax rate. So it basically halves our 12.5% tax rate, giving you a very beneficial overall effective tax rate. In addition, that can be interacted with the R&D tax credit. So again, if you're looking at doing KDB, it may well be the case that your expenditure can qualify for R&D, as previously discussed, but in addition, the profits may ultimately be taxable at 6.25%. So, in terms of interacting the different IP reliefs, there are significant benefits to be had. So a few points on it. A separate claim must be made in respect of each qualifying asset. In certain circumstances, the relief can be applied to a family of assets and not just one single asset. Obviously, as is the relief and the 6.25% rate applies, any loss on the activities is also reduced by 50%. So it's a value basis whereby losses can only be really used at the tax value which they're generated. Large companies will be required to apply transfer pricing rules to the KDB regime. Detailed records must be maintained in terms of the qualifying asset and the type of expenditure that's been incurred and how that calculation links into the modified nexus approach. And as I just discussed, the KDB regime complements the current R&D regime and also the capital allowances regime that I discussed earlier as well, available for intangible assets. One other type of relief which I'd like to just mention briefly as well is the Specialist Signee Relief Programme. So it's for SARP. So this relates to individuals who come into Ireland from other jurisdictions. It's in recognition that Ireland, although we have a very low corporation tax rate of 12.5%, our income tax rates tend to be quite high, and they range from 52 to 55% in terms of marginal tax rates. So in terms of recognising the high income tax rate, SARP was introduced as a way to alleviate the income tax burden on key personnel who may be assigned to Ireland for a period of time. And I suppose one thing to bear in mind here that this is also an incentive for the employee, but it could also be an incentive for a company who's looking to perhaps perform tax equalisation or tax neutralisation for the employee that might be moving across to Ireland. And I suppose it's really aimed at key personnel working for the multinational who has the expertise needed that may not be available just yet in Ireland. So if you're looking to set up a company, there's plenty of resources here, but there might be someone with very specific knowledge to your business or your IP that needs to come to Ireland for a period of time to work here to build up the business. So it is important to realise that there is, a generous enough tax benefit there as well as they come across. So persons who may qualify, it's people who moved to Ireland between 2015 and 2020. They were employed on a full-time basis by the employer for a 6-month period prior to arrival. They must have been employed by someone within a double tax treaty jurisdiction, such as India. And they will have to exercise their employment duties for a minimum of 12 months in Ireland. The relief only applies above 75,000, so the first 75,000 is subject to tax under the ordinary course of our tax regime. As discussed, that can be as high as 52 to 55%, depending on the individual circumstance of the individual. But over 75,000, the tax reduction is 30%, and there's no upper limit on that. There used to be an upper limit on that, but it was removed in Finance Act 2014. So if we took the example of someone earning, say, €200,000, they would get tax relief on the 125,000, basically reducing their income tax at 30% of that. So that could lead to a tax saving of €37.5 thousand for that person who earns €200,000. Under SARP, they're not exempt from, we have the universal social charge or Irish social security, so it is just our income tax, but the universal social charge and PSI is included in the 52 to 55% tax rates that we discussed. But in addition, the employee can also make a claim for relief for the reasonable cost of one return trip from Ireland for the employee, their spouse, and any children of the employee, and that would be allowed on a tax-free basis, which would normally be a taxable benefit in kind for the employee. In addition, the cost of school fees for a child, if they prefer to put them into private education, there's an allowance of 5,000 tax-free that can be paid on behalf of that child. Again, that would ordinarily be a benefit in kind, taxable in Ireland, but under this regime they can avail of this benefit. There are some of the key tax reliefs that are available in Ireland, and they're part of the reason why Ireland is such a popular location for IP and foreign direct investment here, and it's obviously one of the key selling points for the IGA when they're out working with clients and looking to move to Ireland. But I'll pass over to Brian McGilligan, my colleague here, also who will discuss some of the legal aspects of Ireland as an IP location.
That's great. Thank you very much, Declan, and thank you all for attending the webinar this afternoon. It's a pleasure to speak to you, and thank you also to Tanaz, Vishal and the team for organising all of this. I'm going to speak to you about the IP legal environment in Ireland and how robust it is and how it can give assurances to anybody entering the jurisdiction for holding purposes that it is a good place, not only to do business, but to protect and to enforce your rights. I'd like you to take away a key message about this, and that is that Ireland is strong on research, it's strong on the protection of intellectual property rights, and it's also strong on the enforcement of intellectual property rights. With regard to protection and enforcement, let's first of all look at maybe protection, because it's first in the line of how you would address these from a legal perspective. We are part of all of the EU regimes when it comes to the protection of intellectual property rights, and some examples here will be the European Patent Convention, where we're a member state of that, along with another 37 contracting parties. We're also a member of the international system of the Patent Cooperation Treaty, so any of the rights that you have externally will also be recognized under these treaties. Many of you, I assume, will have been following the news in the last number of years and will have seen lots of reference to the next stage of how the EU or Europe will manage patents, and that is the unitary patent system, which will be managed by the Unified Patent Court. At the moment, that process has somewhat stalled. Brexit is one of the reasons, but there's also currently a challenge before the constitutional courts in Germany with regard to the implementation of the unitary patent system there. So while in the future it may become a reality, for the moment any patentee in this jurisdiction will most likely be relying on the European Patent Convention, and to go abroad then the PCT system. But any of you who does have experience of the PCT system, any in particular, will understand that it is a very robust and reliable regime for, I suppose, springboarding to other filings. From a trademark and design perspective, each member state of the European Union, including Ireland, has their own trademark and design national registers. Overlaying that, there is a EU IPO, or European Union Intellectual Property Office, trademark system and design system, whereby it is possible to procure one single trademark that will cover all currently 28 member states, and soon to be 27. And this is a very useful system that we recommend to a lot of our clients, because it is a fairly swift and easy process, and it's in some cases as quick as 4 to 5 months to procure that 28 member state trademark. Same for the designs. There is the Irish national system beneath that then, where it is possible to just procure trademark rights within the Irish system, and they usually take between about 7 to 9 months. Copyright, like many other jurisdictions in the world, is not registrable in this jurisdiction or throughout Europe, but rather is protected by the first to create, or the author who first creates the work. Enforcement of intellectual property rights in Ireland is quite a pro-rights holder jurisdiction when it comes to the recognition and the upholding of the rights of the patentee or the trademark owner or the design owner or the copyright holder in this jurisdiction. We have a specialised section of the High Court here in Ireland called the Commercial Court, and it specifically recognises IP cases as a special case for the treatment of an expedited process through the courts, probably something similar to the Patents County Court in the UK, which some of you may be familiar with. The judges, as a consequence, have good experience of running large patent cases and trademark cases, and so you tend to get some good judgments which will stand up to the test. In some ways, we are seen as more pro-rights holders than some of our neighbours, maybe something on a par with Germany. For instance, here in Ireland, we would be viewed as having quite a rights holder stance when it comes to matters such as the protection of unregistered rights, such as unregistered trademark rights. We would have quite a broad interpretation of the law passing off here in this jurisdiction, which is certainly helpful for all brand holders. What I presume maybe many of you are noticing is these days the crossover between data and intellectual property and how it is impacting significantly. What we have is a regime here where Ireland is recognised as one of the best locations within the EU and indeed the world for the location of data-rich businesses. And indeed, we recently commissioned a report with Forbes around this matter, which involved reaching out to 200 C-suite executives, and all of their feedback was very positive when it came to not only the location of data in Ireland, but the regulatory regime with regard to the interpretation of data. That report is our Europe for Big Data report, and anybody who wishes to access it can come onto our website, or I can send it on to you after this webinar. Go to the next one there. By way of an example around our research and why we are considered strong on research side and why it is a good location for companies looking to come and further their existing IP base, is something that was already touched on by Tanaz in her opening, in that we've a proven international reputation, in particular in the areas of biotech and pharma. Now, this is also equally true for the likes of technology, fintech, and other areas. A key point to note from anyone coming from a common law jurisdiction is that we are a founding member of the EU and the only English-speaking Eurozone common law member post-Brexit. We have a well-established and thriving pharma and biotech sector, and 9 out of the 10 global pharma corporations are located here, 17 out of the 25 global medical device companies are located here, and 33% of the world's contact lenses are manufactured here. I think what the key takeaway from that is Ireland is not just some location where people come to avail of tax credits. It's an overall attractive option from the perspective of planning, the robust nature of the protections and the enforcement, and also the backups in the area of research. The fact that we have had so many of those large medical device and pharma corporations here for a long time now, we're not talking in the last 10 years, but 30 or 40 years or even longer, is that huge vast swathes of knowledge and talent have been built up in the west of Ireland and here in Dublin and the centre of the company, in the institutes for technology and the universities when it comes to research in the pharma and biotech and medical device areas. This is representative of the vibrant and relevant R&D environment. We have well-established and significant research and development supports, which I think has also been mentioned by both Declan and Tanaz, and these are sector-based and specific provided targeted supports and expertise. What you tend to have is clusters that work across the universities, and where there is an attractive open invitation for third parties to come in and to interact with those universities on either a fully funded basis or a partially funded basis for the furtherance of own specific commercial research projects. You'll see one example there is the Biomedical Diagnostics Institute, which is a multidisciplinary team working across 5 universities and 6 large hospitals with significant IP expertise in research tools and diagnostics products. So you can see it's almost like when you come into Ireland, there's a shop window of organisations and research organisations, both in the universities and in the health sector, who are ready to speak to IP-rich companies who are looking to further their IP with further research, or indeed those starting out. I know that's only just kind of a flavour of what it is that makes Ireland an attractive nation for holding, commercialising and exploiting your IP. But again, I would kind of hark back to that kind of key theme or key message I had at the start there, where just to bear in your mind that Ireland is strong on research, it's strong on the protection of IP, and it's strong on the enforcement of IP. And that concludes our presentation, and I suppose we'll open it up to Q&A, and back to you, Tanaz, and your team, I guess.
Thank you, Brian, Declan. The presentation has been very comprehensive and insightful. We have a few questions which we will pose to you, and we have also received a couple of questions from our participants. The first question is, do these rules and regulations which you've been talking about, this IP regime, does it apply to young technology product companies also?
Yes, they do. The rules and regulations with regard to the protection and exploitation certainly do apply to any company, and we would see them as a key tool for commercialization by first protecting them. I suppose I'll let maybe Declan answer as well from his side.
Yeah, so I mean, from a tax perspective, obviously, a lot of our benefits are aimed at startups, and particularly the R&D tax credits and young IP companies. Particularly the R&D tax credit system, whereby, if you're a loss-making company, the refundable nature of the tax credits allows companies to get a tax benefit, even if they don't actually have a tax liability. So we see that as a very positive, positive thing that startup companies and young IP companies that, they can really benefit from that, and they can use those funds then obviously to further invest in their IP activities from a very early stage.
Thank you. The next question is, what if the product is partly developed in Ireland, partly in other EU jurisdictions, but paid for by Ireland?
Yes. So in terms of the R&D tax credit, that activity does not need to be carried on only in Ireland. So there can be, if provided the employees of the company carrying on the R&D are actually employed within a European jurisdiction, provided you're not claiming R&D tax credits in that other jurisdiction, you can actually claim R&D tax credits within Ireland. So, for example, if you had a branch in, Germany or in England or in France, for example, if you have, hubs, as part of your Irish operation that are carrying on certain R&D activities, you can actually claim that R&D tax credit in Ireland, provided you're not claiming, a similar relief or something else in another jurisdiction. So you're not getting a double benefit as such. But in terms of, obviously as a member of the EU, there is free movement of capital and free movement of people. So there are allowances for activities within Europe also, and it would be contrary to EU law to disallow any activities that take place in Europe. So there is the possibility to have Irish operations with branches in foreign EU jurisdictions, which will still qualify for certain of the reliefs.
And then on the protection side, guys, I'm sure many of you are aware that IP is very territorial in nature. So, for instance, if you seek protection for your trademarks or your patents in Ireland, that is the extent of the protection that will be granted. However, you do have access to the EU trademark regime I was mentioning, the design regime, and also the patent regime, where it is possible to seek protection in multiple jurisdictions off the back of one application. That can be either in the patents case, where you can springboard to further applications, or in the trademark case, where it's just one application will get you protection in 28 member states.
Okay, thank you. But the question which I am going to ask you right now is slightly different from the above one. Now, this question asks, what if the product is already registered in other EU countries? Does the benefit of Ireland can still be accrued?
Yeah, so in terms of, I suppose that would depend on the value of the IP. So in terms of our tax depreciation regime, if you're to buy the IP back into Ireland, there is the possibility to get tax depreciation. Now, as I did mention, in terms of BEPS and in terms of employees, there would be a requirement to make sure that you've got substance and employees here. Now, there's no minimum number of employees as such, but you need to have sufficient people on the ground that can actually operate the business, and it becomes a business decision as opposed to a tax minimum number of employees. For example, there is the Noddy case, which the Noddy Rights subsidiary case in the UK, which has kind of strong influence in Ireland. So in that case, only one person was operating the IP business, but it was found that one person was actually capable of running the business as a whole, and he was the only person that was actually needed. So it's never a question of what is the minimum number in Ireland. It's genuinely a question of what's required in order to operate the actual business. So even if the IP is registered elsewhere and developed elsewhere, you could still buy it into Ireland and avail of the IP tax depreciation regime in Ireland. That would not qualify for example, the 6.25% KDB regime, because it's already developed IP, and the KDB is more focused on newly developed IP in Ireland as such and developing it in Ireland. So it would be a case that it would qualify under our tax depreciation regime as opposed to our knowledge development box.
Thank you. This question, which I'm going to ask you right now, is from Sandeep. They were a participant. He wants to know the issues around regulation. Specifically, what regulatory challenges are there for newcomers who are going to be putting up their business in Ireland?
It depends. From a intellectual property regime, you are looking towards the legal regime as a protection rather than a barrier, really. When it comes to products, the regulatory regime will vary depending on the product itself. So let's just say, for instance, it's a medical device. Well, then we'll need to register the device with either the EU or the local national authority. But usually it's easier to go and get what's known as a CE mark with the EU. And once that is procured via the process and the device is classified under the relevant legislation, then again you would see it more of a benefit than a hindrance, in that your product has that stamp and can easily be put on the market and sold on the market. Other products may not necessarily be subject to much regulation at all. Average consumer products I'll be thinking of here. Other systems then, whereby you're operating a very data-heavy system, you will be subject to the General Data Protection Regulation very shortly, or in the meantime the current data protection regime. And again, that is more of a self-certification system, in that there is no specific certification, but it's you need to ensure and satisfy yourself that you are operating with the regime, or risk being subject to very heavy fines. But Tanaz, as you know, my colleague John McGee has already presented quite extensively on the GDPR, and I presume that webinar could be provided to your customers again.
Thank you once again. The next question is around BEPS Action Plan recommendation and CBCR reporting. So how will these affect what you're talking about with regard to IP, etc. in Ireland?
Yes. So in terms of CBCR reporting, just to touch on that briefly. Ireland introduced country-by-country reporting for periods from 1 January 2016. So that has been implemented in full in Ireland. So, if you're the top Irish company in a group, you're required to file your global accounts in Ireland. And if you're a subsidiary, you're required to notify the Irish revenue authorities of who is the reporting entity. So that came in for a period starting 1 Jan 2016. So, we saw our first filing period, I guess, with throughout 2017 in that regard. In terms of BEPS, as I mentioned, our knowledge development box is the first OECD and BEPS compliant IP box in the world. So it has followed the modified nexus approach in full, and it has been approved by the EU as being BEPS compliant. So in terms of what's been introduced since BEPS, that has been BEPS proofed, I guess. So our KGB and our IP, that is BEPS compliant. Our other regimes, our R&D tax credit, they were always in line with OECD recommendations in terms of what constitutes R&D activities. And in addition, our capital allowances regime is deemed to be outside of BEPS because it's a capital allowance as opposed to a profit regime or an IP box regime. So everything I've discussed today is entirely within BEPS, and nothing contravenes BEPS, and therefore all three of those main IP regimes are here to stay in Ireland and are fully BEPS compliant. In terms of the other BEPS action plans, Ireland is fully committed to BEPS and has been implementing certain changes. In a lot of circumstances, Ireland has certain legislation that we deem to be already in line with BEPS, so certain things aren't changing. More in the space of interest deductibility rules and stuff, which Ireland generally has quite strict rules anyways. But then in terms of the MLI, for the most part, Ireland is signing up to most of the provisions of the MLI. I think we've reserved on one position in relation to a small part of the permanent establishment risks that are changing within that. But other than that, Ireland is following the BEPS process and is intending to be fully BEPS compliant. I spoke briefly in relation to there's currently a transfer pricing consultation process underway in Ireland, whereby the government are looking for submissions from various practitioners and advisors in terms of what ways are best to update our transfer pricing legislation and bring that more in line with BEPS. So we expect that process to complete, in the first quarter of 2018. But I think as part of that, we will see just a full implementation of the July 2017 transfer pricing guidelines that were published by the OECD.
Once more. Now, this is the last question which I'm going to ask you. This is a hypothetical case scenario. We want to know that supposing there is only a sale of IP to an Irish company for tax planning, there might not be lots of actual R&D activity happening in Ireland. In such a case, is there any minimum employee requirement to overcome cash box regime under BEPS?
This is kind of what I touched on, Tanaz, in terms of substance. So all of our IP regimes are based on there being some sort of substance in Ireland. So you need to have some employees. There is no minimum employee requirement. There's no specified employee requirement in the legislation anywhere. It is more based on case law and the badges of trade. So you need to be considered to be carrying on a trade in Ireland to avail of both the IP tax depreciation and also the KDB. So in cases where you're buying IP into Ireland, it's unlikely that the KDB will apply. It's more the KDB, the 6.25% rate, is more aimed at development activities in Ireland, whereby the IP is developed in Ireland. So in terms of purchasing IP into Ireland, the key regime there would be the tax depreciation in terms of getting a write down on your acquisition costs when you acquire the IP into Ireland. So although there might not be R&D activity that would suggest the IP is fully developed, there may still be exploitation activities in terms of licensing activities or exploitation of that IP in different manners. So in terms of that activity, that could qualify as a 12.5% trade, and therefore you should be able to get a full write-down on your acquisition costs of that IP. But in terms of the cash box regime and the IP box regimes, it's unlikely in that scenario that will qualify because the IP is developed abroad and it's fully developed. So the KDB is more focused on developing the IP in Ireland and exploiting from Ireland.
Thank you so much, Declan and Brian and Tanaz, for this great presentation. I'm sure that our participants will benefit immensely from the insights which you have provided into our all the rest of the questions that we have with us from the participants, we will be sharing it with you, and our experts will get back to you. Thank you all the participants for being with us for more than 1 hour for this great presentation. Thanks once more.
Thank you, guys. Thank you very much.
And thank you everyone for joining us.